How to fund a living trust in New York. A living trust only protects the assets you actually transfer into it, and simply signing a trust document is not enough under New York law. If you skip the funding step, your assets may still pass through probate in the New York Surrogate's Court, which defeats the entire purpose of creating a living trust. Proper funding involves transferring real estate, bank accounts, and investments into the comprehensive trust estate plan while coordinating beneficiary designations on retirement accounts and life insurance. Under the Estates, Powers, and Trusts Law, Section 7, 1.18, a lifetime trust is only valid as to assets that have been transferred to it. The statute makes clear that a transfer is not accomplished simply by including language in the trust document that recites or describes an assignment of assets. This means you cannot simply list your home or bank accounts in the trust document and assume they are covered. Each asset requires a separate, formal transfer that changes the legal title from your name to the name of the trustee. For assets that can be registered, such as real estate, stocks, and bank accounts, transfer requires recording a deed or completing a registration change. Real estate is typically the most valuable asset people transfer into a living trust estate plan, and it requires careful attention to New York's recording requirements. To move your home or other real property into the trust, you must prepare a new deed that conveys ownership from you individually to yourself as trustee of the trust. The new deed must include the full legal description of the property and name the trust or trustee as the grantee. Under New York Real Property Law, Section 291, the deed must be acknowledged by a notary and then recorded with the county clerk's office in the county where the property is located. Several additional documents typically accompany the deed filing, including Form TP 584 and Form RP 5217 for property outside New York City. Transferring real estate to your own revocable trust generally does not trigger New York State transfer taxes, as long as the transfer is made without consideration. It also typically does not affect your property tax assessment because you remain the beneficial owner of the property during your lifetime. Bank accounts, certificates of deposit, and money market accounts can typically be retitled into your living trust estate plan by working directly with your bank or credit union. The process usually involves bringing a copy of your trust document or a certification of trust to the financial institution and completing their paperwork to change the account title. Some banks in Syracuse and throughout central New York may require a review of the trust document by their legal department before processing the change, which can take several business days. An unfunded or partially funded trust can leave your loved ones facing the same probate proceedings you intended to avoid in the first place. At Davies Law Firm, Syracuse estate planning attorney Frederick P. Davies and William P. Davies help families throughout Onondaga County create and fund comprehensive living trust estate plans. Our revocable trust lawyers work with you to make sure every asset is correctly titled, so your estate plan works as intended. Contact Davies Law Firm at 315 472 6511, located at 210 East Fayette Street, Syracuse, New York, 13202, to schedule your consultation and properly fund your living trust today.